Thank you.
Yield back.
Gentleman from Wisconsin.
Yeah, I don't like being here today. It's a sad state of affairs because you don't like to have to clip the wings of the judiciary or say that sometimes we don't have to obey a judge's order, which is, I think, where this is leading. But we have a lot of judges who are reaching decisions that are just so completely out of line, and where a lot of these decisions are going to revolve around immigration and removing people. And the only reason this has become such a big issue is that we had a president who decided, to the degree which he could, he's not going to enforce the immigration laws of the country. So after you have completely irresponsible president and completely irresponsible judges, you wind up in the mess we are today. Now, just to clarify things, I'll ask, maybe Mr. Larkin, Speaker Gingrich. Obviously, the country's been around now under our current Constitution for about 230 years, what precedents from the early part of our country indicate that injunctions should not be beyond parties directly involved in litigation? In other words, when Abraham Lincoln went to law school, what would he have thought about these decisions?
Well, of course, Lincoln didn't go to law school.
You're right, I was going to correct myself.
He read the law.
You're right.
But look, I've been around long enough that I remember talking with Jefferson. And when I talked to Jefferson, he said, you know, you simply can't have an oligarchy. And if you allow judges to be the final determinants, you by definition have left the people behind and established an oligarchy. I really think if you look at Lincoln, and if you read Fehrenbacher's extraordinarily detailed book on Dred Scott, Lincoln makes the Dred Scott decision the centerpiece of the 1858 campaign. And when Lincoln is very clear about this, think about Lincoln at Gettysburg, when he says government of the people, by the people, and for the people. He's not only referring to Southern slave owners, he's referring to the court. And he's saying, by definition, you cannot usurp the right of the elected officials. Now, if you read the Federalist Papers, it's very clear that the Founding Fathers thought the weakest of the three branches would be the judiciary, that it would always be cautious because it would always be subject to being overwhelmed by the executive and legislative together. And in fact, you all represent the branch the Founding Fathers most feared because they assumed that the people elected by the people would have the greatest power. So we just have to recognize there's a...
And we said they were wise.
Yeah, that's right. Look,
Did
I
we
think there are good reasons to fear the institution I once led.
Can I just add a short supplement to that?
Sure, I'd like to say, did this issue ever come up in the 1840s or 1850s or 1860s or 1870s?
No.
Okay, it was just assumed, it was understood at the time?
The law of equity was party specific. If person one sued person two, the court would remedy whatever harm person one suffered. The court would not then go on and enter an injunction that tried to govern society. That was not the role of the courts. And the Supreme Court has even made that point more recently. They've said the responsibility to adjudicate a case of controversy is quite different from the responsibility to govern the society. The Lewis versus Casey, which is cited in one of my articles, makes this point. So it was not a component of equity in England or, as you put it, in the 1840s, 50s, or 60s. It happened only much later.
Okay, now we're never supposed to, they tell us you're never supposed to ask the Democrat witness, but I'll break with my stuff. Ms. Shaw, what do you think is the strongest example of a case, say, before 1870, in which a district court tried to come up with a ruling that affected the whole country?
We don't have examples that are of the sort of nationwide injunction that we know today. I don't think that's really in question. They are the there's been an enormous increase. The scholarly debate about how kind of
Okay.
sort of how historically grounded this is, goes back and forth, but it's either about a century old or a little more, but I don't think there's much suggestion that there were injunctions of this sort in the early
Okay, that would
the
be an
19th century.
indication that under our Constitution, our forefathers never dreamed we'd have these type of rulings come from somebody who just, it comes from an individual district. But we'll ask, I could tell Speaker Gingrich wanted to get in one more swing here, so we'll let you get in the swing and then I'll.
Look, what we have seen over the long sweep of American history is a gradual, steady increase in the self-esteem and power of lawyers. Marbury versus Madison is totally misrepresented. The fact is that Marshall was terrified of Jefferson, knew that the Jeffersonians would gladly wipe out the court, danced around. It's not revisited until Dred Scott, and Dred Scott's a disaster. And so you really have a long period here where judges didn't think they had the power to define for the country how the country should behave. And what we're living through, and I'm very sympathetic to the agony on the left, because this is if you have Jefferson, Jackson, Lincoln, FDR, and Trump, this is the fifth great cycle of a profound challenge to the existing order. And obviously, these kind of periods are very painful, and they're very dangerous, and you got to work your way through them. And I think this is one of the examples. You have a group of people, well-meaning, I believe, but ideologically deeply convinced that they have the power to overrule the President of the United States. And now the country has to make a decision. Do we, in fact, have alternative presidents in the form of district judges or not? And the country, I think, will overwhelmingly decide that that's impossible. And so, but this is a classic historic, this is what the Congress should be about at its best. This is a classic historic discussion on both sides of how we retain a balance of power between the three branches. And I think that's where we are.
Thank you. We now go to the gentleman from Texas, who's been patiently waiting.